What's up, everybody? It's Jason Cruz here once again with another episode of The Legal Submission. And we are back from that Zuffa antitrust lawsuit hangover. And we have more legal cases to discuss in the world of combat sports. And picking up where we left off, Vince McMahon was being sued by 43-year-old Janelle Grant, uh, alleging of sexual misconduct, sexual trafficking, and other types of issues that was filed in the federal court of Connecticut. McMahon has finally responded to the lawsuit and issuing a motion to strike. And I think when we talked about this a couple months ago, the issue had to relate to the fact that the parties, McMahon and Grant, had signed an NDA, or Grant had signed an NDA, in which McMahon would pay her $3 million in exchange for her not filing a lawsuit or releasing their affair in the public. And bound by that agreement, assuming that she is bound by the agreement, McMahon claims that the lawsuit must go to arbitration. So let's talk about that really quick. Motion to compel arbitration usually occurs where there's a contract and that the contract dictates that if there is a dispute arising out of or related to the contracted issues, it goes to arbitration rather than a lawsuit in court. What are the advantages of arbitration? Well, the arbitration is a private process. There is less legal expense, shorter time frame as far as court case versus an arbitration hearing. It's done in usually a office building in one of the firm's offices or a conference center or something of that matter. And the rules of court still stand, but an arbitrator, not a judge, an arbitrator, a seasoned attorney who's taken the training to become an arbitrator, is the one presiding over the case. The legal issue here is that McMahon wants this case to go to arbitration, uh, less eyes on it. Perhaps it'll be dealt with swiftly. The arbitrations in these particular matters are binding, meaning that unless there's something totally outrageous occurring, the court will not intervene in the arbitrator's ruling on the substantive points. The only real legal filing that may occur is the enforcement of a judgment that the arbitrator issues. So that's arbitration in a nutshell. The cons of arbitration are the fact that you are precluded from the judge, a judge and a jury determining your case. Obviously, with a jury, you could be more persuasive to the story of Janelle Grant from the plaintiff's perspective. A woman that was taken advantage of by McMahon. If you believe her allegations in the complaint, obviously there was issues related to sexual abuse, sexual trafficking, sexual misconduct on the part of McMahon. McMahon's motion to compel arbitration takes a shot at Grant in its preliminary statement. Now, the preliminary statement in motions basically outline the facts related to the case before getting into the legal substantive points. In McMahon's motion to compel arbitration, he points out several things. First of all, he points out the fact that Grant was an educated 43-year-old woman who went to law school. This paints the picture as far as her knowledge, assumed knowledge, that she would know what she was getting into when she signed the NDA. It also talks about the fact that her father's home was foreclosed on, and bringing up a lawsuit related to the foreclosure of the home, and that allegedly dispels the myth that she was grieving her parents' loss and that she was helping them, assist them, nursing them while they were basically on their deathbeds. The lawsuit, the preliminary statement by McMahon comes out and says that her father died prior to meeting McMahon. That's a issue that's probably in dispute as far as the grieving process goes, but McMahon's attorneys point that out. Third one that I noted in the preliminary statement is the fact that it brings in the issue of Grant's fiance, noting that her fiance, a lawyer, naming him, notes the fact that she was having an affair with McMahon and sneaking out of their home to go downstairs to visit McMahon and then coming back, which paints a horrible picture if you are the fiance or the ex-fiance, I assume now. And so the question becomes, does any of this relate to the case, or was McMahon just taking shots at Grant for filing this lawsuit, which he allegedly denies the factual implications in Grant's lawsuit? Grant's attorneys on April 24th filed a motion to strike the quote-unquote baseless, irrelevant, and false statements in the motion's preliminary statement. Grant's attorney states that it was designed solely to harass and intimidate his longtime victim, Janel Grant, a new low. Now, the motion to strike doesn't really do too much here. It essentially strickens from the record the inferences made by McMahon, but the point of the matter is everybody's read what's happened. So that's the harm's been done, basically. But let's get to the substantive issue related to the motion to compel arbitration. The fact of the matter is Vince McMahon's attorneys probably have the legal high road here. Contractual arbitrations usually prevail from the outset. So on a motion to compel arbitration, the trial judge does decide if the case should go to arbitration, if there is a valid arbitration clause. And the law is very specific. If it's a valid arbitration clause, it will go to arbitration. If a party objects to it going to arbitration, it's the arbitrator that decides what jurisdiction, if it should retain the jurisdiction or should it be sent back to the trial court. Only in the instances, I think we haven't seen Grant's opposition yet, but the one case that McMahon's attorneys point out is only if the arbitration clause itself is invalid. Then the trial court may intervene and take the judicial authority. The arbitration clause is seemingly valid. I don't think there was a objection by Grant's attorneys related to this. They make a point, McMahon's attorneys makes a point that Grant had her own attorneys negotiate an NDA. So it's hard to make that argument that the arbitration clause is invalid because an attorney had an opportunity to have an attorney look it over. So what happens in the case that the trial court grants arbitration? Well, we seemingly believe that Grant would oppose it. I think the one argument that they may have, without doing super legal research, is that the agreement was never fulfilled by McMahon. There were payments that he was supposed to make that Grant claims he failed to make. Thus, the contract has been breached. I think that's the big issue. McMahon argues that Grant had already taken the money, so at least the first payment, and thus she conceded the right to the agreement, and thus the agreement should prevail. That's a lot of semantics going on at that point. And the question will be who decides that? Is it the trial court judge or is it an arbitrator? At this point, unless Janelle Grant's attorney point out something further, I think it's the arbitrator that will decide the jurisdiction. So again, motion to compel arbitration actually goes to the trial court judge. Trial court judge does not rule on anything substantive, not of the facts. They rule on the procedural issue. If the procedural issue says, hey, the jurisdiction, the person who decides the substantive facts should be the arbitrator, it goes to the arbitrator. The arbitrator will then hear arguments about it. He'll be like the trial court judge. He'll be like, hey, I will hear the arguments. If you think that it shouldn't be in front of the arbitrator, Ms. Grant, let me know why. And then he will assess it, and then he will make his own decision on that. I would think that this goes to arbitration. It would be a big win for McMahon, simply because in arbitration, he has a easier road to prove his case since it's an arbitrator that's determining it. There's no jury. It's a binding arbitration by a seasoned lawyer. So if McMahon's legal team can persuade one person instead of 6 or 12 that Grant was making all of this up, that there's reasonable doubt that her claims were not correct, then he would prevail. Now we'll see if that happens. But what happens next? Opposition by Grant's attorneys as to the motion to compel arbitration. We'll have a separate legal submission to talk about that. Have a great day. Bye-bye.